Well, I'm back in the chair and the mics are back on. My name is Jeffrey Davis, and this is Radio Entrepreneurs, very proud to say, and hosted by the wonderful law firm of Tarlow, Hart, and Rodgers, and that means flanked to my left is the one, the only, Mark Furman.
Hey, Jeffrey. Great to be with you. Looking forward to our next guest very much.
Great to have you with me, Mark. It's always nice to have you backing me up when we're talking to attorneys with those questions which I would not even think of asking. Our next guest, Nancy Reimer, partner, Freeman, Mathis, and Gray. Welcome.
Thank you. Glad to be here.
Thank you. Why don't you tell us about your practice?
Well, I represent professional services companies, both in litigation when they're sued for malpractice and in risk management services, so to hopefully prevent a malpractice suit from taking place, or if one does take place, it's a little bit less painful as you go through the process of litigation.
So you represent lawyers, accountants, engineers.
Yes, so I primarily represent the lawyers and accountants. My partners represent engineers, architects, real estate professionals. I also represent financial services professionals, pretty much anything other than the doctors. We don't, what we call the blood and guts practice, we don't handle as much of that in our Boston office. Our firm does in other offices, but in Boston we focus on the bloodless type practices.
I'm sorry I have to say this. Do you get second-guessed a lot by attorneys that you're representing?
Even more so by the accountants.
Really?
Well, because when they take
You're
the
just
CPA
defending the attorneys because you're one of them.
No, when they take the CPA exam, there's actually a law section on it.
Right.
So they have experience.
Oh.
So we
You're
actually
being facetious.
we get more questions by the accountants than we do by the lawyers.
Oh, okay. Well, I
That's
get
interesting.
questioned most by a client who spent a year or two in law school before he decided that, it wasn't for him. So,
Geez, and I'm not even an attorney. I just play one on the radio. So,
See, it's that little bit of knowledge.
yes, can go a long way to be dangerous, I know.
Right. It teaches you how to commit malpractice.
So you're saying the lawyers can be easier to deal with because they appreciate what you're doing?
And they know the law. And they know the process. And they understand litigation much more. People that aren't involved in our litigation system, sometimes it's a hard time to explain. Delay is a big thing. You have a hearing and then the court cancels it. There could be a conflict. I mean, there's so many factors that go into it. And it's hard to explain sometimes to lay people, as we call them, why the delay's there.
When I play sports, I play a lot of sports. When I play someone better, I'm better. So do you think working with attorneys has raised your game over the years?
Well, I always prefer to litigate with the big firm attorneys than the solo practitioners, but I think there is something to that. I like the challenge myself. I, too, play a lot of sports, and I think you're right. You do rise to the occasion, but it also challenges you to be better because you need to know more. And he or she who works harder is going to do better.
So what are the most common situations that give rise to professional liability claims against lawyers?
Well,
It's a self-serving question, isn't it?
Yeah, I thought I'd get some free legal advice there. We'll turn to the accountants later.
Forget the management consultants. You just throw them under the bridge.
Right. Well, it varies, and a lot of it varies on the type of practice that the lawyer's involved in. In litigation practice, a lot of times it's as simple as a blown statute of limitations. There's something, a glitch in the docketing system may have happened in their office, or, something just slipped through the cracks. And we get a lot of those. Others, if the practice, depending on what area they're in, the larger practice, more complicated practice, there's always judgment questions. And, in our practice, it seems that the plaintiffs or the clients, they can never be wrong. So if something goes south, it's got to be the lawyer's fault.
Right.
And, 80% of the time, the lawyer didn't do anything wrong. And it's just somebody's questioning.
I was getting excited there. I was thinking, it's always the lawyer's fault.
Now, never the lawyer's fault. It's always a question of the lawyer's judgment. Did they, in any case, you're faced with numerous decisions, and did they make the right decision? And if the client disagrees or the decision turned out to be wrong, all of a sudden they're going to sue you for malpractice. But one important thing to remember is malpractice is not making a mistake. Malpractice is when the lawyer failed to meet the standard of care of the average practitioner in that field. And that's a part that the plaintiffs don't always understand. They just think, well, you made a judgment call and you were wrong, and therefore you're liable for malpractice.
Hindsight couldn't be clearer, could it?
Exactly. It's like Monday morning quarterback.
Right.
You know, you should have thrown the pass to Gronkowski instead of to Edelman or whatever.
You know, I think of malpractice. I actually go a little bit more, maybe it's biased, to the mental health field, where I think a lot more decisions are subjective. They're not working in a team format. A lot of attorneys are working for firms. A lot of doctors are working for hospitals. There's a little bit more of a process of review that happens, let's say, and then in a psychological process where a therapist could be alone and never talks to anyone about their work. But I don't know if you have opinions about that as well. It's something that I've sort of held for years, an opinion that I have.
I don't have much experience in the mental health field or dealing with psychologists or psychiatrists, but a lot of times they are affiliated with practices that's going through, but it's still the same judgment call issue. And we do represent a lot of solo practitioners. Not every lawyer is affiliated with the firm, depending on the type of practice that you have. But even when you are affiliated with the firm, a lot of lawyers don't necessarily consult their partners either.
So,
Right.
you know, we both work in the litigation area. You know, every day we're making judgments and about whether documents are privileged. I recently had to decide whether to fight for a jury on a case I had the plaintiff, a business case, and judgment call. You know, is the jury going to help? We make judgments about particular pieces of evidence. Does it help our client more than it hurts, even though it may both help and hurt? Do we object at trial? You know, what is our theory and theme of the case? All these things are just judgments that are capable of being second-guessed, I would think.
Yeah, that's right. I recently had a case that I tried in March where the plaintiff's counsel strongly believed that the security deposit law applied to his plaintiff's case. I looked at it and I said, it doesn't apply. And there were reasons why, including the fact that the amount of the security deposit was triple of what 1 month's rent was. So just on the face of it, it takes it out of the security deposit law. He insisted that I was wrong. The case went to mediation. The mediator told him she didn't think that the statute applied. He insisted we were both wrong. Took the case all the way to trial. We actually got a defense verdict. And the jury, that was one of the questions. When you try a case, you have a jury questionnaire that goes to the jury, and the jury actually fills it out, and that's how you end up with the verdict, based on how the jury answers the questions. That was one of the questions, and the jury marked off and said, no, it did not apply, and we got a defense verdict. And I'll tell you right now, this guy's still claiming that the jury was wrong and the security deposit statute applied. He'd been told for 2 years that it didn't apply.
Wow.
But that's a judgment call and an example of where a jury can make a mistake, where the lawyer, rather, can make the mistake.
Sure. What about in the accounting area? What are common traps for the unwary accountant?
Yeah, well, there are a number of them for the accountant, and once again, it depends on what field the accountant's in. Accountants primarily fall into 3 categories. They're the tax accountants, the audit accountants, and those who perform consulting services. And the consulting services are a broad range, anything from IT to a forensic accounting practice to all kinds of things. In the tax practice, the most mistakes that we see are the accountant has missed the tax law. An example, we have a recent case where there was a treaty between Germany and the United States that said for the materials and goods that went back and forth, there would be no taxes between the 2 countries. Our client missed that, and for years the client was paying taxes in the States and issuing a dividend in Germany to lower the amount of taxes. It's a significant number at the end of the day, but that is a clear example of a mistake they made in interpreting or missing the tax law. And in an auditing practice, most of the cases that come up there end up being some type of a fraud claim. There was an embezzlement within the company. The auditor goes in and misses it. And although audits are not designed to detect fraud, everyone thinks that they are, including our own Supreme Judicial Court here in Massachusetts. But that usually is not. The scope of the engagement governs what the accountant is required to do and what they've engaged to do. But that's where most of the claims come up, or in the audit they have mischaracterized a certain type of transaction, they've missed certain deductions. That has obviously cost their client money, and that leads to many claims as well.
What about in the consulting area? Do you see many claims there?
I better concentrate.
We actually do. An example would be an accounting firm would recommend to a company that they should create an ESOP. Business owners are trying to figure out, all right, what do I do? I'm getting close to retirement. How do I, maintain my retirement, but also I want my company to live on? What's the best way to do that? And the accountant will advise various steps. One, let's say, could be an ESOP, but then the implementation of the ESOP goes awry. And that would be an example where an accounting firm would be brought in, although accountants and consultants will always tell you that they recommend and advise, they don't implement. And the problem usually falls within the implementation. So that, of course, is the defense that we have. There are other, in the IT field with the consulting, there's all kinds of errors, especially now with all the cyber crimes that are out there. It's almost next to impossible to design an IT system that's going to protect you against some kind of cyber crime. The crooks are miles ahead of the good guys, as we say. And but you always have these breaches. We read about them in the papers every day, from large companies to small firms. And
Right.
that's an area where consultants will get hit on the accounting side.
Great topics. We've been speaking with Nancy Reimer, partner Freeman Mathis and Gray, and with Mark Furman from the law firm of Tarlow, Hart, and Rodgers. Nancy, if someone was looking for you, how would they find you?
Well, they can find me. It's actually Freeman Mathis and Gary. We're over at 60 State Street.
All right.
Our email address, so you can reach me at nreimer, it's REIMER, @fmglaw.com, or at my phone number is 617-963-5969.
Great. Thank you very much. We appreciate you being on the show today. Hope you come back again. Thank you, Mark Furman. And we are going to take a break. We'll be right back after these messages